And we're joined again by legal analyst Romeo Nthambeleni, advocate, as well as a professor in public law at UCT, Professor Cathleen Powell. Professor, let's pick up with you again. The Commission, I mean, we've looked at the arguments of the former President Jacob Zuma, those court papers public. The Commission now is saying that the application by Zuma falls short of all legal requirements. It's riddled with falsehoods and distortions of the law. My question to you both, do you agree with that? And what do you think his chances are tomorrow of getting a rescission?
I do agree. And I think that his chances are zero. We might not hear that tomorrow. The court might take a while to consider its judgment and then come back in a few days' time with the judgment. Having said in the first half of this interview that it may be a good thing that the court is taking so much effort to show it's considering his arguments carefully, let me just add that there is a problem with it too, because it's creating a false sense of entitlement in his followers that he actually deserves to be let free, or that there's a reason to let him free legally. And it also creates a false sense of what the law says. This is actually an open and shut case. The grounds for rescission have not been met. And it's problematic in a way that we're going through the motions when I just can't see how any other conclusion could be reached.
Advocate, are the chances zero?
Yeah, I'm afraid I have to agree with the professor. Rule 42(1) says that when you seek ground for rescission, you must not have been present, in court, and there must be a solid reason why you are not there, and there must be a judgment with the patent era, which was, and the era that is common to the parties, And looking at the circumstances of this matter and how, the courts bent backwards to try and actually accommodate the former president, with all the legal challenges that he has been going through, I don't think you can easily pass that test to say, you were absent, and then there must be a common mistake, that is known between the parties, and the judgment has been granted erroneously. We know the circus that was going on at the Zondo Commission of cat and mouse, which the former president was playing with the commission, and a myriad of opportunities that he was given to come and present evidence. And like I said, surely the law should be tried, and I'm afraid I must agree with my former colleague. It should be tried, and the law must fully take its own course.
Professor, what about, I think Helen Suzman, their foundation has already made this argument in the other application in the Pietermaritzburg High Court, that you can't have dirty hands, in the sense that you can't be in contempt of court and then go to a court and ask for relief. You have to be respecting a previous judgment of the court. Do you think the Constitutional Court will look with some disfavor on the fact that he did not hand himself over within 5 days?
I hope so, because we would like the law to be consistently applied. And the case law is clear on that. He's in contempt, not only for not handing himself over within 5 days, but also for making it clear still now that he will not testify to the Zondo Commission. And that was part of the court order that he initially disobeyed. And his own heads of argument make clear that that contempt is ongoing, because he says in his very finding affidavit, and it's carried out in the heads of argument, that he feels entitled not to obey a court order if he feels it's wrong. And this one he feels is wrong because it's told him to go and testify before a man whom he believes is biased. Now, his contempt it's clear it's ongoing, and in our case law, you cannot ask a court to overturn or to rescind its own judgment before you obey that judgment. You obey it first and then you ask.
Yeah.
So there's another primary step that he has not taken.
Advocate, your thoughts on this, and I mean, there's also been political statements outside Nkandla. At one point, our reporter picked up inconsistencies. The former president was talking about the reasons why he didn't go to the Zondo Commission, and why he left that day when he did without permission, talking about the fact that Zondo was biased in his view. He didn't bring up any of the arguments around taking medicine or anything like that. And the Constitutional Court has previously been critical of his statements around judges, some of which were repeated as well.
Yeah, unfortunately, Francis, in court we need legal arguments. We don't want political arguments, and no, nothing much turns on that. What needs to happen is whether you've brought a proper application before court, and whether your application has got substance in that particular kind of application. And the tone of the language in the affidavit of the former president indicates that he wants things to be done in his own terms. My colleague professor there has actually indicated, you can see through the tone of the affidavit that he says, this is what I expected to happen, and it did not happen. And when it did not happen, this is how I have actually reacted in a manner that I thought it was not going to happen in relation to direct access. Then I was given wrong legal advice and whatnot. But what we need before the court is strong legal arguments and strong basis as to whether there is a proper case made out for a rescission application, which, as we are sitting and have read the papers, both of us independently from each other, think that no prospect has been made.
Zero prospects, you're both saying. You've just mentioned something, though, Advocate, the fact that he says he got bad advice from his lawyers. Do you think the court will have any sympathy for that argument?
No, the court won't entertain that. In his papers, that's what he's actually saying. You are dealing with a former statesman here, the former head of state, who has the opportunity of bringing the proper case before court, without actually making a mockery out of the justice system. So what was happening, as I've previously indicated, that it was like a cat and mouse game that was being played in relation to what was transpiring in the Zondo Commission. So I think the argument that the dog ate my breakfast is not going to cut it to the constitutional court. It's not going to cut it. It's not going to cut it. The constitutional court will say, we are having none of it. Yeah. You had the best advice. You had the best lawyers. You had the senior counsel. You cannot come now and start saying that you have had the best advice.
Professor, you can come in there and also, can you wrap this up and tell us, is this really the end of the road? Because at the time when he approached the Constitutional Court, we always say that's the highest court in the land, no appeals, this is the end of the road. Is this really the end now?
Legally, yes, it is. The Constitutional Court is the highest court of the land. There is no appeal from its decision. There is no basis for a rescission of its decision, so this is it. It's not the end of the story of what happens with Zuma's imprisonment. There's still a question of whether he'll be granted parole. There's still his criminal trial to be run. And of course, there's the political problem of these protests that are being stoked and encouraged nationwide. With people making completely untenable demands on the president to release him, as though the president has the power to do that outside of certain procedures which have not been followed. So it's not the end of the road for the story, but it's the end of the road for the legal case. I think, to wrap it up, the best way of explaining it is, I was asked whether my students in constitutional law had this case in their test, whether there'd been a contempt of court case for their test, with this particular case. And I realized that I couldn't set it because it's too easy.
Sure.
There simply are not enough grey areas to put this in a constitutional court test. We know the answers.
All right, thank you. So end of the road legally, and we at SABC News, of course, will follow that story that continues to play out that you're talking about. Thank you both. That was Advocate Romeo Nthambeleni and Law Professor Cathleen Powell from UCT.